Hello everybody. My fellow partner Claire Smith and I welcome you to our webinar on Australia's National Environmental Law Review, a review of the Environment Protection and Biodiversity Conservation Act, or as we like to call it, the EPBC Act. We'd like to start by acknowledging the traditional custodians of the land on which each of us is sitting across Australia and pay respect to their elders past, present and emerging. As the report we'll be discussing today acknowledges, we have a lot to learn from our Indigenous friends. We'd particularly like to welcome any Indigenous people with us today. So today we'd like to take you on a quick trip through the interim report into the EPBC Act. This is based on an interim review which is carried out by Professor Graeme Samuel, probably best known to Australians as the former head of the ACCC. The EPBC Act features in most discussions of environmental regulation and indeed regulatory reform, even though it's not comprehensive in its control of development. And the reason I think is that it operates most often in the bigger, higher profile development projects throughout Australia, like major infrastructure projects, energy and resources projects, and projects of all kinds in sensitive environmental areas. The Samuel Review provides a once-in-a-decade opportunity to have a look at this significant act and ask some big questions about what we should like to protect and promote our environment at a national level and how we can do that. And as you'll see, the interim report hasn't missed that opportunity. It recommends sweeping changes to the EPBC Act and the way in which it operates. There's a Q&A function at the bottom right-hand corner of your webinar screen, and we encourage you to send any questions you have through as they arise during the webinar. We'll endeavour to answer the questions at the end of the presentation. And this session will also be recorded and available in the coming days. So what does the EPBC Act actually do? Well, the EPBC Act is Australia's primary Commonwealth environmental law. While it has several regulatory schemes dealing with strategic assessments, heritage protection regimes and management of wildlife trade, the most prominent part of it is the project approval scheme, and that's what we're going to focus on today. The Act requires approval for projects or actions which have, will have or are likely to have a significant impact on prescribed matters of national environmental significance, or MNES, the environment generally on Commonwealth land, and the environment generally if carried out by a Commonwealth agency. There's a list of MNES which largely reflect our international agreements to which Australia is a party. I've listed the most commonly applied MNES on the slide you can see. The other one which is applied, I guess, less frequently is the water trigger for water resources in relation to CSG developments and large coal mining developments. Now, the key to understanding how the EPBC Act works and its problems and its possible solutions is to remember that Australia is a federated nation, a union of states and territories, each with their own governments and laws, and a national government with limited but important environmental lawmaking capability. So the Samuel Review is the second mandatory review of the EPBC Act. The first was done about 10 years ago. It was called the Hawke Review, and it also recommended significant changes, but very few of them were actually implemented. This time I think it might be different. Now, I've highlighted some of the terms of reference for the Samuel Review on the slide to show you that it's meant to be a big picture review, but also a review which can propose real and practical changes. Importantly, it's an independent review, so it doesn't reflect government policy, and the government doesn't have to accept it. But the government does have to respond, and as Claire will explain shortly, we've seen some significant responses from the government already. So how is the EPBC Act going? Well, according to Professor Samuel, not very well. This slide sets out pretty much the first two paragraphs of the interim report's summary points. You can see clearly Professor Samuel felt pretty strongly about these points. And he's not alone. There have been many reviews of the EPBC Act over the years by a wide range of individuals and bodies, and most of them have drawn similar conclusions. So what does he recommend we do? Well, quite a lot actually. I've summarised the key recommendations on the slide, and we will cover these briefly today. We will focus probably on some of the key recommendations, which include national environmental standards, devolution to the states or single touch approvals, restoration of biodiversity, increased Indigenous involvement. We'll talk about some of the things he recommends stay the same, such as MNES, and importantly, improved access and better data, which will underpin a lot of these changes. Now, the foundation of the reform that are recommended in the Samuel Review is the establishment of new national environmental standards. These have got two fundamental purposes. Firstly, improved effectiveness of the EPBC Act through strong, clear and nationally consistent standards to drive more sustainable outcomes, and improved efficiency in assessments and decision making, since greater certainty of outcomes by applying the standards will focus proponents and regulators on projects which are environmentally acceptable and the key issues to address for them, and so will drive faster and lower cost assessment processes. The key idea is to move away from process-driven or transactional systems with not enough principled guidance to a system which focuses on good environmental outcomes in a clear and consistent way. Well, let's have a look at some of these national environmental standards and understand what they mean. The report recommends a robust scheme for these standards and a number of key requirements for them. They must be regulatory instruments, not just policies or guidelines. They've got to be legally enforceable. They've got to be granular and measurable, not lofty or aspirational, but also not too prescriptive or process-based. They've got to be concise, precise, quantitative and outcome-oriented, which means they've got to be refined by high-quality information, which Claire's going to discuss shortly. They should provide flexibility for development without compromising sustainability. And in fact, they need to allow tracking towards better sustainability across the nation. They must be applied in decision-making unless the decision-maker can demonstrate that the public interest and the national interest is best served otherwise. All sounds pretty simple, really. Now, the standards would be made by the Commonwealth in a formal process under the EPBC Act in consultation with the states, the territories and other stakeholders, but not by agreement with them, so we don't end up with a lowest common denominator outcome. The Interim report recommends interim standards to facilitate rapid reform and streamlining and includes some prototypes for the MNES to stimulate a bit of discussion. It says the standards should be reviewed and refined over time as a form of continuous improvement. Now, it's interesting to note that the Interim report deliberately doesn't include a standard, a prototype, for water resources MNES, on the basis that the EPBC Act doesn't currently allow decisions about the water trigger to be made at the state level. Now, this suggests that the standards really are all about devolution of decision-making to the states and territories. So how do the standards work? Well, the concept of national environmental standards sounds sensible and it offers a valuable role for the environmental law of the Commonwealth. But the Interim report raises some big questions about the proposal for standards. For example, to what do they apply? Do they apply to Commonwealth, state and territory legislative schemes? Do they apply to the schemes under the legislative systems like planning schemes? Do they apply to project decisions? Do they apply to project implementation, so carrying out a project? Or do they apply to all of these things? What's the result of non-compliance? If a standard isn't followed in making a law, does that mean the law's invalid? If it's not followed in granting an approval, is the approval invalid? If a project proponent doesn't carry out a project in accordance with a standard, is the proponent in breach? I think it's most likely that standards will be pitched at the approval and strategic planning phases, and the obligation to comply will be on decision makers rather than proponents. But of course that could leave proponents high and dry if their approvals are at risk. How much discretion is there in the standards? The prototypes leave little room for discretion in some cases. For example, the prototype standard for world and national heritage says that an action cannot cause or contribute to a detrimental change to the world or national heritage values of a property or place. So does that mean that any detrimental impact requires a refusal of an application for approval? And how does the public interest and national interest exception work? Does it apply to important infrastructure, for example, perhaps a new road or a railway line, a new power station, or even a renewable energy hub? You can see there's still a lot of work to do on the standards concept. But as I said before, perhaps the standards are directed really at devolution of the approval roles from the EPBC Act down to the states and territories. The interim report confirms what we all know, I think. There's too much duplication of Commonwealth and state approval laws, and efforts to harmonise and streamline haven't gone far enough. Just in case we're not sure about this, the interim report provides a few sobering statistics from submissions. Combined state and Commonwealth approvals for resources projects can take, on average, 3 or more years. Now, sadly, that sounds quite fast to me based on the experience of some of our clients. And the Property Council of Australia estimates that approval delays can add up to $37,000 to the cost of a new home in some greenfield developments. So the interim report introduces the concept of devolution as a way of overcoming these problems, while still delivering good national environmental outcomes through the application of the standards. So I've used this word devolution a few times. It's because the interim report uses the word. What does it mean? Well, I think it really means accrediting states and territories to grant EPBC Act approvals. Now that sounds a lot like an approval bilateral agreement, and the Commonwealth Government has already indicated that it's heading in that direction as an interim step. That's already provided for in the EPBC Act, of course. But I think Professor Samuel has chosen his words carefully. Why else would he use a word like devolution? I think what he wants to do is emphasise a specific accreditation model, which is underpinned by the proposed national environmental standards and maintains an active role for the Commonwealth. As the interim report says, this is not about the Commonwealth getting out of the business of environmental regulation. On the contrary, it will stay very much involved under the interim report's recommendations. So, what is this model? Well, it really involves a 5-step process, and I'll take you through the 5 steps that Professor Samuel's outlined now. Firstly, it's the making of the national environmental standards, which we've discussed briefly already. They'll provide the benchmark for accreditation of states and territories. Then it involves the state and territory governments opting in for accreditation and demonstrating that their legal systems meet the environmental standards in order to get that accreditation. Thirdly, it involves a formal accreditation process by the Commonwealth Minister after taking advice from a proposed new body called the Ecologically Sustainable Development Committee, which will provide real advice to the Minister. Then it involves a transparent assurance framework with opportunities for the Commonwealth to step in if a state or territory is not delivering on the terms of its accreditation. And finally, it involves regular review and adaptive management, which includes Commonwealth oversight and perhaps ongoing refinement of the terms of accreditation, as well as the national standards which underpin it. So, it sounds like a great idea, but of course it's easier said than done. I think most of the model could be achieved via the existing EPBC Act and approval bilateral agreements, but certainly not all of it. There are some key parts missing. For example, a robust scheme for standards and Commonwealth step-in rights would need legislative change. And there's a lot of things to look out for in the devolution model. I'll give you a few examples. Will the devolved decision maker, so that's the state or the territory, or perhaps even a local council in some cases, have less discretion than the Commonwealth in making an EPBC Act decision? I think probably it will have less discretion. It certainly couldn't have more than the Commonwealth. What are the requirements for accreditation? Will we see significant reviews of state and territory laws in order to get accreditation? Some of this happened in 2014-2015 in preparation for the last tilt at approval bilateral agreements, which you might recall was ultimately turned down in the Senate. Will this review process happen again? Will we see major changes to state and territory laws in order to get accreditation? How will the monitoring, compliance and enforcement mechanisms actually be done? As I said before, will this create a new risk for project approvals? And what about the exclusions, the ongoing Commonwealth role? The interim report says that the Commonwealth would continue to be the approver in some situations, including where accredited arrangements are not in place or can't be used for some reason, at the request of the state or a territory. The Commonwealth steps in on national interest grounds. The relevant activity is on Commonwealth land, and I think that's a really significant issue for a number of key proponents and key projects that we're looking at the moment. Or the relevant activity is undertaken by a Commonwealth agency or is undertaken outside a state or territory's jurisdiction. So again, there's a lot more thinking to do on the devolution model. So having talked a little bit about the National Environmental Standards and the process of giving EPBC Act approval decision-making power to states and territories, I'd now like to talk a little bit about one of the other key concepts in the report, which is about restoration of biodiversity. And we're talking about the concept of restoration, not decline. This is a key focus of the interim report. It wants to see restoration of biodiversity, not just maintenance of the existing standards. The interim report notes the continuing rapid decline of biodiversity under the EPBC Act, and it does point the finger at offsets. The EPBC Act does not deal specifically with offsets. That's done via a 2012 policy document which the federal government issued. And while the policy espouses the principle of avoid, mitigate, and then offset only for residual impacts which can't be avoided or mitigated, that's not being done in practice according to the Samuel review. The interim report says that offsets have become the norm rather than the exception, and their design and implementation means there's often a net loss for the environment. Key problems include that the EPBC Act offsets often involve purchasing and locking up land with biodiversity values as compensation for development. But it's not really clear whether the biodiversity in the locked up land was actually ever under threat or will be improved with the lockup. So the question is, where's the offset benefit? Or, as we describe it, the additionality. And also, advanced offsets are not well recognised. So the project proponent's expected to be a developer and potentially a biodiversity site manager, and is often not incentivised to consider offsets before applying for a project approval. So we can see here on the slide there's a couple of key statistics at the bottom which just indicate and reinforce the concerns we have and the Samuel review has about the decline in biodiversity. That's what it's trying to arrest with this concept of restoration, not decline. So how does it propose to do this? Well, the interim report recommends renewed emphasis on avoidance and mitigation with offsets as a last resort, and legal requirements to impose this rather than policy positions to encourage it. It also sees promise in a market-based incentive for restoration. So specialist land managers could be encouraged to conserve and enhance biodiversity values on their land, and especially improve biodiversity on degraded land to demonstrate that additionality which the Samuel review suggests is missing in many cases and which is required for genuine biodiversity offsets. They could then sell the benefits of their work to developers who need those offsets. Now, this is starting to sound a little like the key principles of the Biodiversity Offset Credit Scheme in New South Wales. But Professor Samuel doesn't refer to that scheme as a model. Rather, he'd like to establish a new model. He also says he's still thinking about this, and so he's going to consider it in some more detail before issuing his final report later this year. So now I'd like to move on to a couple of the other key issues which the Samuel review addresses. And I'll hand over to Claire, who's going to say something about those, and then also talk about the way forward.
Thanks, Nick. So Nick's described at some level of detail these national environmental standards, which are one of Professor Samuel's key pillars. The other thing that he identified as a key failing with the existing EPBC Act is the fact that decisions are based on a project-by-project level. This gives rise effectively to cumulative impacts not being assessed. And so one of his key pillars to support these changes are adaptive plans, and they are on a national level and a regional level. And on the national level, these are strategic plans. They're for what he calls big ticket items. So pervasive issues such as feral animals and pests, adapting to climate change and habitat management. These strategic national plans are also intended to provide a guide for Commonwealth and Commonwealth ongoing actions, as Nick said, because they still will be involved, and also direct research and funding at a national level. The regional or landscape plans, as he refers to them, there's three sorts of those, one of which is already in existence in the EPBC Act, the strategic assessments, but he's introduced two new types of plans, or would like two new types of plans introduced. The first is what he calls a regional recovery plans, and these are to be developed by the Commonwealth. So they won't have the lowest common denominator. They will have input from the states and the territories, but ultimately they will be developed and approved by the Commonwealth. And these, he thinks, are really the key mechanism to identify the areas regionally that need protection, conservation and restoration. And therefore they'll also identify where investment is required to deliver the greatest environmental benefits. Bioregional plans, on the other hand, are to be developed largely by states and territories and then approved or accredited by the Commonwealth. They need to be consistent with the national environmental standards and the recovery plans, and they're really about setting clear rules to manage competing land uses. You'll know from some of the coal mining in the Hunter Valley region, there's been a lot of debate, a lot of regional planning anyway in New South Wales around protecting certain areas, saying where mining can and can't go. And in fact, the government's just released another strategic position on that issue. And so they'll identify the competing land uses at a regional level. And they'll also, it appears it's not entirely clear how they will work yet, but they will have some similarities to strategic assessment. So as Nick says, it's not entirely clear whether you'll still need an EPBC referral or not. But I think the intention is if you have these bioregional plans in place, or as you already have with a strategic assessment, they will identify where development, assessment and approval can occur without that referral process and without any further assessment. So finally, strategic assessments, they have been around for a long time in the original EPBC Act. They have been developed by both states and proponents, but he does identify the complexity, the resource intensiveness of them, and the fact that they're inflexible. Once they're set, they can't be amended. And so while he suggests they're retained, he also suggests various mechanisms to make them more flexible and really to respond and be adaptive. So Professor Samuel clearly feels extremely strongly about Indigenous engagement and heritage, and that comes across very, very clearly from the language that he uses in the interim review. He talks about things like there being a culture of tokenism and symbolism, and what he means there is that while they have an Indigenous Advisory Committee, that committee is reliant on the minister to invite their opinions, and historically that hasn't always happened. He also says the EPBC Act lags well behind leading practice and refers to both the Victorian legislation and Northern Territory legislation as being far more advanced, and that the EPBC Act prioritises views of Western science over Indigenous knowledge, and their views are greatly diluted. He says Indigenous Australians are entitled to expect stronger national level protection. And the other area that he goes into is the Commonwealth National Parks, and the fact that at the moment the way that they are set up do not meet the aspirations of the traditional owners. because ultimately the director of the national parks determines what doesn't happen within those national parks. And while they do have joint boards, they haven't been working. The other thing he touches on briefly is the Aboriginal and Torres Strait Islander Heritage Protection Act. And he uses that as an example to, again, demonstrate how little Indigenous engagement is used in the EPBC Act, and the fact that under that Act, they can only intervene at the last moment once the approvals have been done. There is no mechanism to ensure that their engagement is mandatory right from the beginning of the process. So what does he suggest to reform that? Importantly, he recognises that any reforms need to be co-designed with input from Indigenous Australians. As he's obviously very keen on national environmental standards, he thinks one of these should be specifically developed for best practice on Indigenous engagement, and that Indigenous engagement needs to be reflected in all the other standards, certainly the NES on the matters of national environmental significance. He also thinks that the old Indigenous Aboriginal Committee needs to be completely recast into a new Indigenous Knowledge and Engagement Committee, and that should have a much stronger role to interact with the Environment Minister and to have a role not only in setting and administrating that standard, but also the development of the regional plans. He again recommends, although that obviously won't be within the EPBC Act remit, a comprehensive review of other national level laws, and that there needs to be action in relation to the national parks and a way that traditional owners and national parks can work together to facilitate a better outcome. A lot of the submissions that were provided in the consultation phase talked about potentially expanding the MNES, for example, to include a broader biodiversity requirement. Professor Samuel was quite firm on that. He said that he's going to stick with the current MNES, and to expand would result in muddled responsibilities leading to poor accountability, duplication and inefficiency. Nick's already touched on the water trigger. That stays for the moment, but the intention is for that to be largely devolved to the states following the accreditation of a national standard. The Commonwealth will retain a limited role, though. They will. He recognises that it is important for them to still be involved in any project where there's a risk of irreversible depletion of water resources or contamination of cross-border water resources, where you've got different states with different imperatives. The other thing that was a huge amount of submissions on the climate change trigger, or the greenhouse gas trigger. He clearly realised that was an area he obviously has bitten off a lot with his review. This was one issue he wasn't prepared to put his toe in the water on, and he effectively sidetracked it, said that it was already duplicated in existing frameworks, and there was no need for the EPBC Act to include a greenhouse trigger. That said, if you look at the detail, and particularly the prototype standards at the back, he talks about proposals needing to disclose their full emissions profile, which would include Scope 3 emissions, and also the imperative to consider impacts under climate change modelling. And the government has already come out and said that they're not, emissions are already dealt with through NGES and other things, and they don't need to deal with that. And in New South Wales, for example, there's a bill at the moment that's stuck somewhere in the system that deals exactly with this issue and has arisen as a result of a Land and Environment Court case a few years ago. So obviously it's a very contentious, very political issue. Professor Samuel's findings on data are very interesting and extremely relevant. He recognises rightly that decision makers, proponents and the community, they don't have access to the best available data and science, and this results in a raft of different problems. There's suboptimal decision making at the Commonwealth level. There's inefficiency and additional costs for business. There's poor transparency with the community, which leads to distrust and poor analysis of cumulative impacts. And he goes into some detail as to why this is. He says that historically gathering has been fragmented and disparate. The department's systems are antiquated. They haven't got into the whole big data area yet, like, for example, health or the economy and all of the modelling that can be done with the vast amount of data in those areas. It's not shared between departments or indeed between different governments. It's in inaccessible formats, and very importantly, there's proponent data is not in these different databases, and that's because largely proprietary reasons. It's protected by IP and copyright. And he uses the terminology he uses that he's obviously thought very clearly about here, and he refers a number of times in the report to there needing to be a quantum shift in the way that data is gathered and managed and in the accessibility of that. And I think, it's a huge challenge. Obviously, if he gets it right, I think it would have massive benefits, but it is a big challenge. And so what does he propose? He proposes, again, this is the exact language that he uses, a national environmental information supply chain. And that's to deliver the right information to the right people at the right time to those who need it. And he also talks about the single source of truth. And that's so decision makers can rely on this single source of truth to inform their decisions. Proponents can rely on this single source of truth to understand and design their projects. And the community can rely on this single source of truth to understand the impacts of those projects. Now, he also realises that this is going to cost a lot and that there needs to be a national custodian of that database who needs to be adequately resourced. Now, he didn't go so far in the interim report as to nominate which national custodian that would be, although there are a number of clear candidates like CSIRO, Bureau of Meteorology, that there's certainly national bodies that could take this on. Given the importance, we also have a national environmental standard for that too, and that's really about ensuring the consistency of the information that's provided, the transparency and the sharing, and the need, very importantly, for that information to include proponent or applicant data. And again, the reason that it's important to develop this data set is not just to provide that granularity that Nick talks about with the national environmental standards, but to allow that modelling to occur, to allow the future modelling of climate adaptation and other impacts. And he recognises it will be a big challenge. It will require a lot of investment and a complete overhaul of existing systems. Who's going to pay for it? He's a little bit more sketchy about that, although he does indicate that it will be both proponents and government that will be expected to put their hands in their pockets. Another area he feels very strongly about, and this is really to restore trust, both for applicants going through the system, and indeed the community is having a strong compliance, enforcement and assurance system. And he has recommended an independent cop on the beat, as he calls it. And that needs to have no association, he says, with the minister or the department. It needs to be properly resourced and have a much broader toolkit of powers. And so that might include remediation orders, for example, where financial penalties would not be a sufficient deterrent, a wider range of penalty notices that could apply to a wider range of people. He also talks about how that independent COP role would change over time. So initially focusing on compliance and enforcement while they are the approval body, but following the devolution of the approval role, the shift, again, as Nick mentioned, to an assurance role, both on monitoring the implementation by the states and territories of the regional plans, and auditing their performance generally, and also potentially giving step-in rights where there have been major project-level breaches and states and territories haven't taken action. Again, the government came out very quickly after the interim review and said they did not support an independent COP. They said it was an extra layer of bureaucracy. It was not warranted. But they did clearly state and agree with the need for an assurance role from the Commonwealth around states and territories once the devolution has occurred. This is a legal review of decisions. This is an issue that the lawyers have been clearly very interested in. There were an enormous amount of submissions about this particular issue. On the one hand, industry wanting, and government, federal government wanting to reduce the standing or the current broad standing under the EPBC Act. And then on the other, NGOs and environmental organisations wanting a full merits review. Where Professor Samuel has ended up in the interim report is in between. He said that he's not convinced that standing should be curtailed. He says that the courts already do a good job of weeding out vexatious litigants. And he also says, which I agree with, that even if you did curtail standing, the environmental groups would find a way. They would find an individual that did have a direct impact and they would co-opt them onto the proceedings. So it wouldn't really make a difference anyway. Interestingly, that he has proposed the introduction of what he calls a limited merits review on the papers. And you know, we're all still scratching our heads, wondering exactly what that might look like. He says that he's done this because the department, because currently there's only a judicial review right for environmental impact approval decisions. What's happened is the department has focused very much on a box-ticking exercise. They're very focused on process, and he says that's been at the expense of good environmental outcomes for the environment. He wants to redial that, change it a bit, shift the focus. He thinks by introducing a limited merits review right, that will do that. I suppose from my own personal perspective, from litigation in court, especially in the Land and Environment Court, a lot of these issues would require expert evidence. If you're testing the strength of an expert on either side, the obvious way to do that is cross-examination. If it's on the papers, obviously that can't occur. I think there needs to be some further thought in that area. Importantly, he recognises there needs to be greater transparency of decision making. Again, he says that some of these judicial reviews have really been commenced to get further information out of the government. There's a lot of freedom of information requests, and he says this is an easy fix. It's something that can be done straight away. And finally, he recommends, as Nick referred to, this independent ESD committee to advise the minister, and that would be on things like the management plans, but also a range of other issues. And they're really similar to how, I mean, the PAC no longer has that role, the Independent Planning Commission no longer has that role in New South Wales, but they used to have this review role for various issues, and the minister would take their views into consideration. So he ends this review with talking about 3 phases of reform. I think he has, to some extent, been guided by the last review and the fact that potentially it was all too hard and didn't go anywhere, and so he split it up into 3 phases. His first phase is all about what he says is the easy fixes. Here he talks about, and Nick's already referred to this, the making the interim national environmental standards, allowing that devolution of decision making to states and territories, and improving that transparency by publishing all decision materials associated with the approvals. Phase 2, he sees, needs to be started now as well, but that has a more ongoing development role. That's around really getting sustained engagement with Indigenous Australians, getting that national custodian for the database on board, looking at mechanisms and offset markets to leverage investment and private investment, particularly in restoration, and establishing that monitoring, reporting and evaluation framework. And then finally, phase 3, which is this complete legislative overhaul, and really a complete review and rewrite of the EPBC Act. I mean, currently it's enormous. It's 500 and something or other provisions. It needs to be simplified. He says it needs to be recast along a specific lines, functional lines, and that he's hopeful by then you'll have a full suite of national environmental standards. You'll have the settings for reviewing those national and regional plans, and you'll be able to input, well, the government's already rejected that, but there'll be changes, the independent regulator, but there'll be changes to the structure of those statutory advisory committees. So what next? Consultation is still ongoing as we speak. It closes on the 17th of August. There is, if you click on to the website, there's a have your say button that you can push, and you can fill in a questionnaire. Some of the boxes are word limited, some of them aren't. But very interestingly, the government has already come out and said that they already have legislative amendments that they're drafting. They say that those legislative amendments will be introduced by the end of August. Presumably they must be to legislate for those interim standards and the bilateral approvals, as Nick's talked about. And so there's clearly an imperative on federal government to push this forward, to, as they say, remove the red tape, to allow and to, as they have done, indeed in New South Wales, is to get some of these projects through and get them going. The other thing that he has done is he's set up this consultative group, and this includes key bodies across the spectrum. So EDO, Property Council, Australian Conservation Foundation, BCA, Minerals Council, but also key individuals, for example, Professor Burnett from the ANU. And they meet every 2 weeks, and they're given homework, And their main role is between now and when the final report is provided, which he says will be provided on the 31st of October. Their role is to flesh out these protocol standards and develop interim standards that presumably then can form the basis of that devolution process. All I will say about that is that, again, that is a mammoth task. You know, I'm sure that everyone on that consultative group is working very hard to achieve that, but the concern I have would be if they don't have that sufficient level of granularity, whether you could truly get a position where you can devolve to the states and territories. So that's all I have to say. I think we have about 15 minutes left for questions. Yeah. So do you want to...
Yeah, look, there's a couple of questions which have come through so far. Thank you for those. Please send some more in. As Claire says, we've got a bit of time to address them. The first question which has come through is a great question, actually. What's the likelihood of these recommendations being adopted in a post-COVID world where the emphasis is likely to be economic activity and reducing regulations? Claire, I've got a couple of things I'd like to say. I'm interested in your views on that too. But I actually think there's quite a strong impetus for sustainable working out of the COVID crisis and for environmental issues to be at the forefront of our recovery. And I know there's been a lot of talk and a lot of speculation that perhaps economic issues will trump environmental issues, no pun intended. But I think they can actually work together, and I think that there's a lot of interest in making them work together. You'll see, for example, the establishment of renewable energy hubs in New South Wales and in other states too. You'll see a renewed focus at the corporate level on ESG, which of course includes environmental issues being at the forefront of boards' decision making. We have an Environment Minister in New South Wales who said he wants to double the population of koalas in this state by 2050. These are the sorts of things which are occurring whilst we're in a COVID crisis. So I do think that there is a significant interest and a significant impetus in maintaining good environmental outcomes and driving for better sustainable outcomes as we move our way out of the COVID crisis. Claire, did you want to comment too?
Yeah, I'll just take it from a slightly different angle. I mean, what they're actually going to do is reduce that red tape. So they're actually going to make it much easier to get your approval if you're a proponent. And they're also, particularly with the data sections of the report, quite a lot of the things that he's done and the way that he's framed his recommendations are to improve efficiency, to reduce duplication, and to actually make it easier. I mean, the only issue I have is really kind of comprehending quite how those national environmental standards are going to look and how quickly you can get that database online. But I mean, I personally think that's a phenomenal recommendation. It's something that nationally we desperately need. And part of the failings of the Act over the last 20 years has been because it's all been dealt with on a project-by-project basis. Some of the issues have got very political, and it's allowed that to happen. I mean, what he's talking about now is having these regional plans that will clearly set out where you can develop, where you can't. In some cases, you might not even need an approval. So there's a lot of streamlining here that I think will happen, and actually post-COVID they want. And if you look at some of the government press releases on this, they're talking about these changes as a way to kickstart, development and to really get it through the process. So I think there's a pretty good likelihood that some of these recommendations will be adopted. What worries me is that they will adopt the easy fixes, so the interim standards and the devolution, and then that's where they'll stop.
Yeah, look, I think there's a real risk of that happening if we don't look at the report as a whole. I have to say there are some terrific ideas in the report. I agree wholeheartedly with Claire there. And the focus on national environmental standards and using that as the benchmark for accreditation of the states and territories really highlights the fact that Professor Samuel's trying to focus on the big issues here. He wants to see outcomes rather than process. And I think if we can look at that as the focus of the report, I think there is a real opportunity, even for the federal government, which is looking to have some quick wins in the next couple of months, to deliver on some much better environmental outcomes. A lot of the things that Professor Samuel's talked about have been in discussion at the state and federal level for quite some time. So some of the ideas are not so new, but I think the interim report gives them additional impetus, and I think that there's a real prospect we'll see some good results from this review. Did you want to take the next question or pick a question?
I can take an easy one. What are the positions of the states and territories on the devolution? My understanding is that they're all, I understand that they're all keen and that they will be putting their hat in the ring. So that's that one.
Yeah. I've heard that Western Australia is looking to be the first to get devolved responsibilities. So for those West Australians, you're leading the charge at the moment, but that just puts out a challenge to the other states, obviously.
Was anything said about improving the regime for split referrals and or stage projects?
I can say a couple of things and then I'm sure you've got some thoughts on that too. There wasn't a lot said about that, but I have to say, and I'm sure Claire's found this too, that is a really tricky issue for multi-stage, large-scale complex projects, particularly infrastructure projects or projects with a long lifespan, for example, resources projects. I suspect at this stage that was a matter probably too detailed for the big pictures that Professor Samuel's trying to address at the moment. But I do think that that's got to be part of any sort of legislative review and legislative revision of the Act. It really exposes the shortcomings of the Act, where we try to have a staged process for these larger, more sort of longer duration projects, and the EPBC Act doesn't really enable us to cope very well with that. We have seen the federal government, I guess, massage the way in which the Act works to try and accommodate that, but it'd be a lot simpler if the Act properly addressed those issues. So I think we'd expect to see, whether or not it's coming through the Samuel review and the report recommendations, we'd expect to see some legislative amendment try to deal with those issues and facilitate what we might call split referrals, but certainly facilitate stage project approvals.
Yeah, so I have what I'm doing at the moment for a Commonwealth department, and I agree they're not easy. Nick's right, there wasn't anything specifically said in the interim report about those. I expect that he's hoping that a lot of the adaptive and the regional planning will assist. He does talk a lot about, as well, these projects that last for many, many years and the difficulty of having advanced offsets and the need for there to be a real hard think around the offset market and potentially, obviously, the need for financial offsets as well as like-for-like offsets and where they should be directed to get the most bang for your buck. I thought all of that was a little bit light. I think that he's hoping that in the next couple of months he can flesh all of that out.
I think so, yeah. There's Professor Samuel's flagged in a number of parts of the report a desire to think more about some of the issues. So I think that we'll expect a little more detail on some of the issues in the final report. Certainly, I think for those of us who are dealing with split referrals, there would be a lot of sense in marking those as key issues as part of the survey response to the interim report. So absolutely make that known to Professor Samuel so that he's aware of it and focuses on it in his final report. Now, there's a question about the Hawke Review, which we mentioned early on in the presentation. That was the last 10-yearly review and the first, indeed, of the EPBC Act. Were many of those review recommendations remade in this interim report, and are they more likely to be implemented? Funny that you mentioned that, actually, and I suspect it's from somebody who's familiar with the Hawke Review, because there is a lot of similarity in some of the key issues. I think the focus on national environmental standards and some of the other initiatives are sort of newer features of the Samuel review. But concern about the inadequacies of the existing legislation has been around for a long time and was certainly addressed in the Hawke Review. In fact, the Hawke Review suggested we rewrite the Act just like the Samuel Review is suggesting. I think there's a stronger mood for reform now, so I would expect to see more of the key recommendations in this review being implemented in some way than we saw with the Hawke Review. So maybe it's my nature, but I'm generally more optimistic about some reforms from this review, even if they're the same sorts of things which were said in the Hawke Review.
We've got another question here on cost recovery. I note that the current cost recovery efforts by the Commonwealth Department often result in fees that are excessive. The review notes that proponents and governments should fund some of the reforms. Is there any commentary on how this will occur or changes that might occur to cost recovery? He's very light on in terms of how all of this will be funded, but he does clearly say that proponents as well as governments will be expected to fund part of this. But that's all. And you know, I have actually myself done a submission on behalf of a client on some of the Commonwealth fees and the excessiveness of that. So I do understand the issue. It's just not clear at this stage how that will be refunded. But what he does clearly intend is that really most of the enforcement and compliance will end up happening once the devolution occurs at the state level. And so it will be the state level enforcement mechanisms that will kick in, and the Commonwealth will only step in a very limited circumstances.
Yeah, I absolutely agree with that. The question, I guess, looks like it's probably focusing on proponent issues, and they're, as Claire says, very significant issues. But we're also aware that a number of state governments are starting to ask questions about how all of these devolved responsibilities will be funded. Will the federal government provide more funding for environmental assurance and approvals? So I can see a bit of a contest looming there too between the state governments and the federal government, which of course is a hallmark of our federal system. And I don't think that issue is going to go away anytime soon. Well, folks, I think that's about time now. We're just on 1 o'clock. I'd like to thank everybody for joining us. Thank you for your enthusiastic questions. I hope you've really enjoyed the session. I hope you've learned a few things, and perhaps this has sparked some interest in some issues that you hadn't been aware of before, or perhaps renewed your interest in some of the challenges that you already know about the EPBC Act. We're very happy to pick up the conversation with you separately if you like, and as I mentioned before, this presentation should be available online within the coming days. So thank you again, have a great afternoon, and we look forward to catching up with you again soon.
Thank you.